G'day, watch this.
Professor Anne Twomey is the Professor of Constitutional Law at the University of Sydney, and she's graciously agreed to this interview. She will be speaking on the law. What she says is not her opinion about the issues, it's really about the law, the state of the law. And thank you very much for agreeing to this, Professor. Could I ask you about the issue which is coming up all the time in the media, and that is same-sex marriage? Is the Commonwealth in a position to legislate in relation to the recognition of same-sex marriage? What are the considerations about that?
Okay, the Constitution says that the Commonwealth has a power to make laws with respect to marriage, but there's a big issue now as to what marriage actually means. Does it have the meaning that it had in 1901, at the time the Constitution came into force, or does it have a contemporary meaning now? Those who would take the view of original intent, that you have to look to what it meant when it was enacted, would say that marriage clearly just means a union of a man and a woman. However, other people would argue that instead, in interpreting the Constitution, you need to take into account contemporary meaning. But even if you take into account contemporary meaning now, there is a real controversy as to what the term marriage means now. It's not cut and dried either way. So there are issues about what type of evidence, for example, the High Court would take into account if it were to try and ascertain contemporary meaning. Does it look at opinion polls? Does it look at, literature or what's in the newspaper or letters to the editor? On what basis can you say that the word marriage has changed? Ultimately, only the High Court could decide whether the meaning of the term marriage had changed since 1901, and until you had such a decision, you really couldn't be sure whether the Commonwealth could legislate with respect to same-sex marriage.
If they could legislate with respect to same-sex marriage, could they also legislate in relation to polygamy?
Possibly. Again, it would be a question as to whether you're taking a contemporary meaning of marriage or whether you're looking at the historic meaning of marriage. Polygamy, of course, has much longer background, I guess, than same-sex marriage. I mean, polygamy has been in existence for a long time. It's still recognised in many countries, and indeed it is recognised to some extent in Australia in relation to people who have come to this country who already have polygamous marriages. But in terms of looking at the community and contemporary meaning of marriage and whether that would now encompass polygamous marriages, I think there'd be much more difficult to establish some kind of groundswell of support for a change in the meaning of marriage to accommodate polygamous marriages as opposed to monogamous marriages.
So the Constitution empowers the Federal Parliament to legislate with respect to marriage. What right then do the states and territories have to legislate in relation to same-sex marriage? Okay,
so this is the other difficult side of the argument. First of all, I should explain that the Commonwealth can only legislate with respect to things where it has a specific head of power. The states, however, have what's known as plenary legislative powers. So they can legislate with respect to absolutely anything unless either A, the Constitution specifically takes the power away from them, which is pretty rare, or B, the Commonwealth has legislated validly in relation to that area and the state law conflicts with the Commonwealth law, leaving the state law inoperative. Apart from those two constraints, the states can legislate about anything. So if the Commonwealth could not at all legislate with respect to same-sex marriage, that would leave the field completely clear for the states to enter into that area and legislate in relation to same-sex marriage. It becomes more difficult, however, if the Commonwealth can legislate with respect to same-sex marriage, and in legislating about marriage, it has purported to cover the whole field of marriage but exclude regulation of same-sex marriage, then it's possible that any state law that allowed same-sex marriage would conflict with the Commonwealth law and therefore be inoperative. So that's where the problem lies.
If I recall correctly, there was an amendment introduced by the Howard government which defined marriage as a union between a man and a woman. Would that be a reasonable argument to indicate an intention to occupy the whole field and thereby exclude the states?
Well, it's funny because people are actually arguing it both ways at the moment. So the Tasmanian Solicitor General is arguing that when the Marriage Act defined marriage as being between a man and a woman only, it was just carving out one sector of the Commonwealth's field. It wasn't moving in at all to the other part of the field being same-sex marriage. So the Marriage Act only covers this particular area of marriage between a man and a woman, doesn't cover anything else, leaving the field free for the states to come in. Other people, however, would argue that in making that definition, what the Commonwealth actually was doing was trying to cover the entire field but exclude from that field same-sex marriage. In the end, it's a matter of interpretation, and it's something that the High Court would have to decide.
Let's assume the Legislative Assembly of Tasmania and the Council, I gather that there's opposition in the Legislative Council, let's assume the Tasmanian Parliament passes a same-sex marriage act. And the Commonwealth, the federal government, although opposed to it, does nothing about it. Who would have standing to challenge the Tasmanian legislation in the High Court? Could anybody, any Christian minister, for example, a priest, take that to the High Court?
No, I think that's a really interesting question. First of all, there may be an issue with others. Well, I think other states could challenge, well, constitutionality of laws. Although you'd think it would be pretty odd if a state would challenge the constitutional validity of a law of another state, so I suppose that would be a bit peculiar. Possibly marriage celebrants, people who were authorised to conduct marriages. There'd be a question, first of all, as to what the Tasmanian law said. If it in any way compelled marriage celebrants to provide equal marriage rights to everybody, including doing same-sex marriages where a person felt an objection to doing so, I think they would have a right to do so. It's possible the churches might have standing to bring such a proceeding. It depends upon whether the person has some kind of real interest in the matter that is greater than the interests of the ordinary person on the street.
Could you say, for example, the Catholic Church?
It might certainly try, but then there would be questions as to what its interest was in preventing or challenging the validity of marriages under a same-sex marriage act. I'm not sure. I just don't know.
Thank you very much, Professor.